how can the natural law find expression in the critical area of the family and marriage? Well, let me propose that this is why Proposition 8 is so critical. I propose to you 3 reasons why Prop 8 is worth fighting for. First, it expresses the truth about the nature of marriage as a civil institution. The law is a great teacher. Let her teach the truth about marriage. Second, Proposition 8 preserves in the law an expression of the principle that marriage is between a man and a woman, and that this is the authentic basis of the family and society. Here we can consider Proposition 8 analogous to fetal homicide statutes. Roe versus Wade forecloses the political process from decisively resolving the abortion question and regulates the unborn to the status of non-person. However, fetal homicide statutes stand as both an expression of the truth in the law and a stark contradiction to the legally entrenched position that the unborn are not persons. They keep the struggle for justice alive, standing as a critical reminder of what is at stake in the abortion question and providing a basis to expand the legal expression of the right to life from the moment of conception. I think it's fair to say Proposition 8 plays this role regarding marriage and the family. Third, by maintaining the principle in the law that marriage is a union between a man and a woman, Proposition 8 at least mitigates the argument that those who hold this principle as true are bigots. This is a very important cultural issue. Proposition 8 maintains a space in society for those who support authentic marriage to state their views and undertake to convince others. Now, Proposition 8 was possible because of the ability of the people to amend the California Constitution by majority vote. It was their sovereign act within this state. The judicial and political class, the legislature and the judiciary, may have abandoned the natural law, but the people are free to act in accordance with the natural law and step by step alter and change the legal environment in California for the family and marriage. This process certainly has its own problems, and those who hold to the natural law will not always prevail. However, under the initiative process, the issue is decided among the people, where the inclinations of the natural law can be felt and understood in their everyday life, and where those who advocate the principle that the family based on the mutual self-giving of husband and wife is the first vital cell of society can argue, persuade, and continue ceaselessly to act for the common good. And it's important to remember that any such effort must first be based on and always express our love for our fellow human beings, including our fellow citizens who are homosexual persons. It should be not lost on us that the right of the people to amend the California Constitution by majority vote was a product of the 1911 revision of our state's Constitution. This was an expression of the progressive era. Remember that from civics and history? Hiram Walker, and no, Hiram Walker was even more progressive. Hiram Johnson and Robert LaFollette. Hiram Walker continues to be progressive, essentially so. And I think an expression of the natural law, if you can. Now, that progressive era, the effort was made to break the hold of economic interests on the legislature and the law and let the people decide. Now, today, this right to amend the California Constitution by a majority vote can break the hold of the legislative and judicial class on the legal environment for the family and marriage. Now, Perry versus Schwarzenegger is the case in the United States District Court for the Northern District of California, currently before Judge Vaughn Walker in San Francisco. The plaintiffs are represented by 2 of this country's best trial attorneys, Theodore Olson and David Boies, who actually oppose each other in Bush v. Gore. Reportedly, they're being bankrolled by a number of wealthy members of the Hollywood community. The plaintiffs assert that Proposition 8 violates the United States Constitution guarantees of due process of law and equal protection. They base this claim on the same argument as the plaintiffs in the in-re marriage cases and on a further ground that Proposition 8 was animated by animus, an invidious and hateful intent or purpose against gays and lesbians. It's interesting because this last point was considered by the California Supreme Court in a sense. In fact, the court found that the laws including Proposition 22, reserving the word marriage for heterosexual couples, were not enacted with invidious intent or purpose. So if the laws weren't enacted by invidious intent and purpose, how is it that the restoration of those laws, well, whatever. They don't pay me to make the argument. Now this case is ongoing and closing arguments have not been scheduled. It's important to note that those who supported Proposition 8 are being labeled bigots by the plaintiffs, and the plaintiffs are asking the court to, in effect, find that hate against homosexual persons was an essential reason Proposition 8 passed. It's also important to note how such constitutional cases proceed. Here we have two well-known attorneys who have access to considerable talents of their respective large law firms and financial backers prepared to spend millions of dollars. The case is brought in federal district court before a judge who is appointed by life and who will make the decision on his own. The trial consists essentially of a battle between academic experts. In a space of 2 to 3 weeks, some 10 or so experts from major universities testified as their opinions on matters such as the purpose of marriage, its changing characteristics, whether therapy can change homosexuals. For example, the lead-off plaintiff's expert witness, was Professor Nancy Cott, who holds a chair in history at Harvard University. And it is reported that Professor Cott testified, among other things, that in her opinion, marriage was not a static institution, that it has evolved over time by shedding inequalities. She testified to the importance of marriage, as seen by the fact that upon emancipation, former slaves flocked to get married. She supports same-sex marriage. Once Judge Wachter makes his decision, it can be appealed to the Ninth Circuit Court of Appeals, where it will be heard by either 3 or 11 judges, and then on to the United States Supreme Court, where 5 judges can decide the matter. If you wish, in the question and answer period, I will hazard an opinion as the ultimate outcome. The testimony in court was all very interesting, as are the opinions of judges. However, let us move toward the end of this talk with this question. Should the law treat marriage as an institution to be described by elite social scientists, historians, and philosophers who testify in trial under rules of evidence and then to be ultimately ruled upon by a judiciary, or should the law treat marriage more as a lived experience of a people who are free to express themselves about its very nature through the democratic process? Another way to put it is, who do we follow? People like my mother had a 9th grade education. She was married for 36 years and raised 2 sons. Do we follow her? Professor Cott. Finally, who should decide? Now, the Manhattan Declaration, the document that brings us here, has this to say. The impulse to redefine marriage in order to recognize same-sex marriage and multiple partner relationships is a symptom rather than a cause of the erosion of the marriage culture. It reflects a loss of understanding of the meaning of marriage as embodied in our civil and religious law and in the philosophical tradition that contributed to shaping the law. Yet it is critical that the impulse be resisted, for yielding to it would mean abandoning the possibility of restoring a sound understanding of marriage, and with it, the hope of rebuilding a healthy marriage culture. It would lock into place the false and destructive belief that marriage is all about romance and other adult satisfactions. I break from the text. Personal autonomy. And not in any intrinsic way about procreation and the unique character and value of acts and relationships whose meaning is shaped by their aptness for generation, promotion, and protection of life. In spousal communion and in the rearing of children, who are as gifts from God, are the fruit of their parents' marital love, we discover the profound reasons for and benefits of the marriage covenant. Who decides? Who will build the marriage culture? I propose that retaining the right of the people of this state to define marriage is where we should pitch our tent. What do you think?